This program is brought to you by Emory University.
Refer to my PowerPoint. Thank you to Barton. I'm happy to be here. I learned so much from each of you that I'm always happy to be invited because it's always an education for me. I'm sandwiched in between a legal expert, Richard, and a defects expert, Deborah, and honestly, my presentation touches on both. So I don't intend to be repetitive, and I may skip over some of my PowerPoint, but you have that as a handout for any of the information you want to refer to. Give us just a second and we'll get started.
Okay, you tap just to change slides.
Just on a slide.
Yeah, so if it has something that is animation in there, so like I think the previous one was that, just tap it and your animation will come up.
Perfect.
Okay.
All right, I'll go ahead and get started. So this is my first slide, and Barton actually contacted me and said, hey, did you realize there are accidentally symbols after guardianship, or is that intentional? And I said, no, it's intentional, because from my perspective as Director of Office of the Child Advocate, this is a very hot topic, right, from a practice stakeholder standpoint. I mean, this is a hot topic, and it gets me hot under the collar. So that's why I put that there. How many of you practice, and this is a problem for you right now? Some of you, or an issue. All right, so that's why I have that there. Let me just tell you, OCA does different things, but how it's relevant to guardianships is this. OCA has jurisdiction and is legislatively mandated to investigate any cases referred to OCA in which the Department of Family and Children's Services has been involved in the life of a child in the last 5 years. And we can investigate any agency involved in that investigation. So you can understand we have a lot of relatives, a lot of parents complaining to OCA. Once we start investigating those, we obviously get into issues of guardianship. So that's my involvement and knowledge. Richard, I suck at this. I'm sorry, I'm sorry, I forgot we're being taped. Okay, here we go. So one of the reasons we're discussing guardianships is they are often characterized as more legally durable than a transfer of custody. So that's good from a permanency perspective. They're more flexible than adoption because it doesn't terminate a parent's rights. They still have rights to their children. Often guardianship will be given to someone they know or have a good relationship with, so they can still have a relationship with their children, right? That's a good thing. And permanent guardianship is legally recognized as a permanency option. And Richard just gave you all the law and very accurate, great information about how you can accomplish that. So those are all good points about guardianships. How do I... Clearly, I'm not a child. My children know these things well. What was I asked to address today? Public policy and experience of stakeholders. Again, I've heard a lot from various stakeholders about guardianships in my capacity, and I will address that today. A couple of the points you've already heard from Richard about the law, and this just recites the statute. But some of the things that were important to me to point out to you about probate court guardianships, they are not a permanency option, but it's written to accomplish some very good things. And by that I mean, it clearly states that the guardian will have the same power as a parent has over that child. That's a good thing. They have the same ability to make the educational decisions, exercise reasonable care, diligence, prudence, to act as a fiduciary in the minor's best interest. These are all very positive things. Certainly there are circumstances in which temporary guardianship through the probate court is appropriate, right? It's not a good permanency option. If there are issues of dependency, it may not be a good circumstance, but there are certainly appropriate uses for temporary guardianship. And it's very specific in what's laid out in this statute. To expend money of the minor for the current needs of the minor. If they get a big chunk of money that they need to save for the future needs, it specifically states how they do that in the best interest of the minor. Respect the rights and dignity of the minor. How much law do you see in Title 15 that outlines that any agency is to respect the rights and dignity of the minor? Has anyone seen it in Title 15? If so, point it out to me. Right? So this is a good law. This is a good thing in the right circumstances. So I just wanted to point that out. All right, I'm going to move on then to talk about, maybe. All right, Richard, you're going to have to give me technical assistance. He said tap it. Yeah. Tap. Richard, I really do just tap it? I feel very incompetent. Right now, I just don't feel comfortable. It's broken. I broke it. That's better.
Okay.
Perfect. Thank you.
Okay, no problem.
All right, so this just continues on some of the probate court responsibilities that are delineated in the code section. You have to keep the court informed of the guardian's current address. The other piece that I want to point out that the probate court does for the temporary guardianship, which is very significant in my mind, it specifically states what the guardian is not personally liable for. Yay, that's great. It limits the guardian's personal liability. They're not liable for the minor's expenses, for the acts or omissions of the minor, right? Really good thing. So it does protect the guardian. So again, just good legislation in the right circumstances. As Richard's already talked about, okay, I give. There we go. Transfer to juvenile court. He's already talked about that if there is, if they want to dissolve temporary guardianship in probate court, it's generally as a practice transferred to the juvenile court, right? And that's what's going to happen. So that the juvenile court can then deal with a hearing to decide what needs to happen to the temporary guardianship. And that, I think, is generally statewide what tends to happen. A couple of side notes about probate court I want to point out is that there is permanent guardianship possible in certain circumstances and that the best interest of the minor is the standard. Now, what are the policy issues, practice issues that are problems with a probate court temporary guardianship? So now let's get into the policy issues. Number one, when this code section was first enacted, guess what was seen statistically? It probably won't surprise you. A decrease in the number of then deprivation, now called dependency actions, right? And an increase in the number of filings of temporary guardianship in probate court. That's number one. Number two, when these cases started getting transferred to the juvenile courts from the probate courts, there were no procedures, statutes, court rules, case law telling juvenile courts, here's how you should handle these transfers. So as we all know, that often happens in Georgia, every juvenile court in every county, handles it differently. They had to come up with their own ways to handle these cases. So that's an issue when you're trying to practice in those courts and they're trying to determine how to handle those cases. I'm going to continue talking about practice issues. We're having technical difficulties.
Oh, sorry.
That's okay. I am tapping. I can't get it to work. Thank you. There it is. I know, and it didn't go. It wouldn't go. All right, that's it now. We're good.
Okay.
All right.
Let's sit up here.
No, it's not this one. Okay. Here's the thing. What's on this is not what's up there. I apologize, just a moment. What's on this right there is not that. So I don't know how to fix that.
Okay. Hey, what? I'll just go over here and tell me when it gets to the right
Oh, the
spot.
connection was lost.
Oh, it was?
Yes.
Okay.
So this isn't connected anymore.
Okay, which slide do you want to be on?
I don't know because it's not on there. It says guardianships established. It should be one before that. So try. There we go. That's it. Thank you. Guardianships established in probate court are inherently temporary because they can be revoked at any time by the parents. Richard's already touched on that. So it doesn't offer the permanency from the child welfare perspective. And it doesn't meet the state and federal contemplated welfare laws and regulations because it's supposed to be a more durable agreement than just custody. So that's a problem. Next slide if possible.
Okay.
So there are also some additional barriers to permanency and family-centered practice if you use probate court guardianships. Number one, high filing fees. Number 2, guardianships in probate court don't address the safety, child support, or visitation. Number 3, guardianships do not include services for the child, the parent, or the guardian, and they can't be enforced. If the parent comes back and takes the child, the guardian doesn't have any recourse. So, based on that and all the policy considerations around it, there's very valid argument that because of those inherent limitations, these guardianships are not appropriate when there are findings of dependency. Because when there are issues of dependency, physical abuse, mental health issues, substance abuse, neglect, all of those require change, right, to safely return the children to the parents. And if you don't have that change, you're not going to be able to protect the children and return them home safely. If there's no case plan, if there are no services, it's not going to be effective. I want to use an example that's very real to me of an example of when this wouldn't work. There's a recent case from Chatham County. Has anyone read about it? It was a 22-year-old mother. Her youngest is 8 months old. The next is 2 years old. The next is 4 years old. Okay, she does have family in the area. The 2-month-old is deceased. When the police responded as first responder, there were some pills on her bed, and the mother literally, the baby was deceased in the bed with the mother. And so I think the initial first response is a safe sleep issue, and the mother rolled over on the baby. The mother's reaction when the police responded to a call they received from a family member was not to get the baby or to see what happened, was to lick the sheets. They've done drug tests on all 3 of the children. All 3 tested exceedingly high for methamphetamines, as did the mother. So the mother's in jail. There's family support. So let's assume in this case, what if the mother or family support talked to an attorney who said, okay, she's in jail, these other 2 children, 2 and 4, they may need medical care, they may need educational care, whatever needs they have. Okay, let's go get you guardianship because she's in jail. And what is that going to accomplish? To anyone who knows child welfare law, it's going to keep defects at bay. Let's be honest. It's going to keep them at bay. She's got issues, she's in jail, and her child's dead. So let's go to probate court. Mom agrees you can have custody of her 2 children. There's nothing anyone can do for that to happen. Mom's obviously got a meth problem. Nobody can stop it. They have temporary guardianship, revocable at will. Keep that in mind. What if she bails out? Very possible. She could then go pick up those 2 children. So there are scenarios, and that's what keeps me up at night, those situations where it's not appropriate. And what's worse is, this is a parent who needs help. It's an addiction. In order for her to eventually raise her children, she needs assistance from the state. So that's one of the reasons that it really is so important that when there are issues of dependency, it's not used in the wrong way. So those issues can be addressed. All right, let's talk about some of the other problems, and that's one of the ones I just talked about, a very real example of. The fact of the matter is probate temporary custody can be used in circumstances to avoid defects from entering into their lives, because frankly most don't want defects involved in their lives. The other issue, and this was based on a paper by Judge Peggy Walker in 2012, and OCA participated in that paper. Melissa, I believe, participated in this paper and made recommendations. And one of the things that Judge Walker pointed out is that probate courts and judges typically don't have training on child abuse and neglect and child welfare and services needed. And so when they are looking at families, even if they're in a rural community and know what's going on with the family, they may not have the training and understanding to know what that means, what the needs are, what the services are. So that piece is missing if they're going to look into those issues. The other piece that is a policy concern, if a temporary guardianship is used through the probate court, go to 13.
Is this the right one?
You know, what's interesting is it's not that on this, but yes, that's the right one. Thank you. It just doesn't match. Is that the juvenile court can make a no reasonable efforts finding, right? So if it's transferred and nothing's been done and the temporary guardianship, which frankly is often probably the case because a guardian has custody and they may not need anything to care for the child, and the department hasn't been providing services, then the juvenile court can say no reasonable efforts, department wasn't providing services, we're not going to trawl down the federal 4E funding, and that's bad. So that's another policy issue, practice issue, if temporary guardianship is used in probate court in the wrong circumstances. Again, I reiterate, there are right, good circumstances to use that tool in your toolbox, but there are some circumstances when it is not the right tool. Would you mind going to the next one, Richard, given this just doesn't match? That would be fabulous. Thank you. I know we've already talked, Richard's talked about permanent guardianship. I'm not going to belabor that and the details of that and the effect of the guardianship order. We're going to skip those 2 slides. But let's talk about the misuse of guardianship. So what is the issue with guardianship from the department's perspective? And let me tell you what happened. I heard from Director Cagle when I was in my office one day, and you can skip that slide if you would, and that one, we've already covered that. Guardianship's not allowed anymore by the department. And I flipped out and said, wait a minute, I'm coming to Beach Street. What do you mean? And it's kind of ironic because here, here's a director who's dealing with numbers have gone from 7,000 to 10,000 kids in foster care. And there are 1 to 2 child deaths in the state of Georgia a day, and I'm saying, wait, you got an issue. You can't take that tool out of the toolbox. So I actually went and spoke to him and said, please, this is a legal option. Don't change policy to say DFACs can't use it. But what he said to me was, I've been involved with the department's work for a very long time, and its misuse is a problem. Because if a department comes in and does just what I said in that example with the 3 children, one of whom's now deceased, and says, oh, and this happens, what if you go in the back hall and say, well, if they go get temporary guardianship next door in probate court before we get heard, I can't file, we can't proceed on our dependency petition. And that happens, guess what happens? Even if it's against policy, even if this isn't what should happen, services aren't provided, the department's case gets closed or inadvertently not worked because all the fires and emergencies are coming in, right? And all the people are having to deal with the emergencies. So as a result, nothing happens to provide services to the family, and it's bad outcomes. Parent goes and picks up the kid, and they're still using meth, and something happens to that child. It's not worth the risk to the department. That's what he explained to me. So the result was a change in DFAC's policy. And it does not apply, I want to point out, to children 14 and over. And DFACs can request a waiver. I'm going to get into some more specifics. But the other thing is that Director Cagle made very clear to me that he does intend to put together a committee to work on a best plan to deal with the issue of guardianships. So I would recommend that you reach out, perhaps speak to Deborah if you or a group know that you want to be heard on this issue, so you can be involved in that forum. All right, next slide, if you don't mind. This again says connection lost. All right, so let's look at this. DFAC staff are therefore prohibited from requesting, pursuing, suggesting, or consenting to a temporary guardianship during any stage of DFAC's involvement with a child and or family. The use of temporary guardianship contradicts the agency's goal of ensuring a safe permanent home for children by the very nature of it being temporary. Period. No exceptions. DFACs is not allowed to use temporary guardianship as an option for children that they are working with. Has anyone in the room experienced the opposite of that recently? Excellent question. This was written in a memo January 15, and I'm assuming Deborah's going to address the policy that resulted from this memo written by Director Cagle. Is that fair, Deborah?
Well, I'm going to talk more about the permanency piece of it, but I can speak to the why.
Okay. So Deborah was just saying, for those watching, she'll speak as to the why. But this was January of 15. So I just want to ask, is anyone out there dealing with cases in court in which the department is recommending or utilizing temporary guardianship? So it was before, right? So before January 15, you might have seen it. It's probably not happening now. Yes, ma'am?
I would say the difference that I see.
Oh, just a minute. I forgot. You need the mic to record.
All right.
working in Cobb County as a child advocate attorney. What I see the difference is that there's cases that will get in that are not truly dependency cases. They are truly temporary guardianship cases, but because DFACS has instituted this policy, we're getting these cases that are screened in where, you know, mom and grandma basically get worked out. I've even had one where I had been in court and there was previous paperwork that was filed and just couldn't be paid for. That we ended up going through a whole case just to get the guardianship granted because DFACS couldn't, you know, no one could tell the parent and the grandmother that they could have done this, you know, separately. So I kind of get the opposite, is that we're getting, you know, I don't want to say it's a lot of cases, but I have several cases where it's not an issue of, it's just they can't say anything about it. So we'll get the cases and it's not truly dependency. There's no abuse, there's no neglect, and there's no abandonment. So we're just dealing with those kind of cases now. Yeah, basically.
So let me ask this, why are they in juvenile court instead of probate court? Or are they transferred from probate court to
Because someone
juvenile?
calls DFACS.
Right,
Now DFACS is involved.
okay.
No one can tell them, so now we'll be in court. You know, now we're in court with a complaint saying that there's no legal guardian.
Oh, okay. So I'll just repeat for those that are watching, it's situations in which DFACS is called, there's no legal guardian. And so while there may not be evidence of neglect or physical abuse, emotional abuse, sexual abuse, etc., there's no legal guardian, so you're in a position where there needs to be a legal guardian for the child.
Right. But the issue is there is a legal guardian. I mean, there's not a legal, there's a parent
Right.
who's accessible.
Right.
But no one can tell the parent and the person who's taking care of the child, you can resolve this by going to probate, so they open up a new
Right.
complaint.
So the department's not in a position to tell them you can resolve this by going to probate court. And that's the feedback I've gotten. The cases that OCA has investigated and have been referred to us is a frustration with an overall blanket statement, right? To say you can never do this. You can never use temporary guardianship, period. And that was my panic when I literally ran over and said, I've got to see you, I've got to see you, I've got to see you. This doesn't make sense to me. Help me understand. Now, it's for the right reason, and I respect why it was done, right? You don't want misuse because families need services to be rehabilitated so they can care for their own children. That's the right way our system should work to protect children. But it was being misused, and many people have told me it's been misused. Maybe it's a training issue, don't know. But the other part, and this again was in a memo January 15, and I'll add the date because that was a good question. But let's read this. In addition, and this again is from Director Cagle, DFACS staff shall not seek permanent guardianship in child protective services cases. That means investigations, family support services, and family preservation services, as CPS cases are unlikely to meet the legal standards threshold associated with a permanent guardianship. What does this not include? What types of cases can DFACS still recommend permanent guardianship? Anyone notice? Foster parents, foster care cases. And that's good, right? Foster care cases are where it should be at a point where you're having to make a different kind of decision for the kids. Often, foster care cases where it starts to be concurrent planning, or reunification's been going on for 15 out of 22. What are our options? Well, if TPR is not appropriate, then DFACS in those situations can still recommend permanent guardianship or file for permanent guardianship. Yes, Lisa. Wait for the microphone. Lisa next, and then Richard and anyone else.
All right, thank you. This is actually one of the main reasons I came to this today, because none of my counties are doing any guardianship of any kind. It just stopped. I have 3 different counties, there's 3 different reasons as to why, so I wanted to know. I've heard that there were certain reasons, certain ways that we could, but every county is scared to, they're just not doing it. And it doesn't make sense to me. I'm doing TPRs on cases that I am not even close to getting a TPR. I just have to, this time to tell them. So I would love to find out, and for the counties to know when they can't do it. Some of the other counties can do it. My counties are like, we're not doing any of it.
And And we have to have microphones, so I'll give it to you in just a minute. And I'm going to do answers, ask all those questions, and then I'll use the microphone and then give it to you.
Okay, Ashley, I mean, my question is going to follow just right from what Lisa is asking. And I guess it deals with this interpretation of CPS cases. We're here talking about cases where there has not yet been a removal to an adjudication of dependency, placement, and foster care, correct?
I'm not going to say there hasn't been a finding of dependency, because you can file for dependency in an
Right.
investigation. But generally, there will not have been a removal.
Okay, so
These are protective order cases.
we're talking about a case where there has not been a disposition of placement of
Removing.
temporary custody in the Department of Family and Children's Services.
Generally.
Okay.
Does that answer it? Or
That does answer it.
I know.
I was just gonna say, I'm in Cherokee, which is one of Lisa's counties, and I have a case right now where the only reason the department is even entertaining permanent guardianship is because the child has no viable parent that's going to be getting this child back. And he's, I think, 11. The closest relative isn't 10 years older than him because it's his brother, and therefore they can't adopt. And that's one of the things that the judge has actually told me as a guardian ad litem that I might have to file because the department might not even do it.
Okay. Can you follow me if I walk to them? Is that possible or not?
Let's see, I can follow you that far.
Could I have that microphone? No, I can't. Can I have that microphone? Let me answer along the way, because I've got too many responses, and then go back to Melinda, if you don't mind, Melinda, because I can't keep it all, because I've got some comments. Sorry to do that. It's such valuable information, though. Lisa, first, this is one of the very issues that I raised with the department when all of this came up. If let me rephrase that. If misuse of guardianships for years is because, as we all know, it takes a long time for policy to trickle down to front line, often for all of us, even as lawyers, to implement new laws, right? Then who's to say new policy to not use guardianships is going to get to the frontline staff accurately, immediately? So one of my positions was, how are we going to ensure that frontline staff at the department knows how to use the new policy? Since this was issued in between then and now, it's kind of shaken out to be clarified. Yes, the department can use permanent guardianships in foster care cases. So I would submit it's still a training issue. And I will take this back and suggest that somehow they disseminate that specific item. But I would say as SAGs, you can communicate that with your client, and you can loop me in, and I'll loop state defects in appropriately. It is simply a matter of training and continuing to train. Deborah, did you have another response to that? And then I wanted to answer this lady's position.
Yeah, this is actually going to be part of.
Use that, so it's recorded.
Thank you. I plan to go into detail around permanent guardianship and the requirements and policies that we put out recently that addresses when permanent guardianship is appropriate as a permanency plan. So, and I have many examples, so I promise hopefully to clarify and clear up for everybody during my presentation about the use of permanent guardianship for permanency plan.
But any of you feel free to reach out to OCA if your communities have not been trained adequately and are not aware of that, because I can assist with that piece. Because again, we have to get it to the frontline workers so that it can be properly used. That's part of the issue always with all of our careers and what we do. You had that same issue basically, right? You stated that they are using TPR, or you were basically instructed to file because the caretaker is 1 year too young, and you would have to file that. I'd like you to listen to Deborah's presentation and see if it sounds like DFACS could do a permanent guardianship, and then speak to the SAG in your county and see how that goes. Feel free to reach out to one of us if that's not successful. It's just an education. That's all it is. It's an education for all of us to learn how to properly do this. I know Melinda had a question. Thank you.
Actually, this goes to something that the gentleman mentioned. How is this going to affect permanent guardianships now that shelter care orders have to go through the courts now?
Expand on that?
I was informed as of October 1st that all shelter care orders are, in essence, defunct, and now they have to come in front of the juvenile court judges to be heard as a petition.
Has anyone else heard that in their community?
That's true. It starts October 1st.
Are we talking about the safety resource
And I was
issue?
told,
Flush out what you've heard. Anything more?
as of October 1st, because of the misuse of shelter care safety plans, all cases will now have to be brought as a petition for dependency actions in front of the judge.
Can I have the microphone? That's me. I can clarify. Everybody put your things down so you can't throw them at me. Another issue identified at OCA is the number of children being left in safety resources for many, many, many months inappropriately. And so I identified 700 children who had been left for 6 months to a year in safety resources with no services being provided to the families, right? And I'm not blaming anyone. It's just an inadvertent often. You have to put out the fires. As a result, those children who are safe and protected, right, you tend to forget about those families sometimes. Those numbers were too high. We did some different things to work with the department to get those numbers down. I commend Director Cagle with all of his actions, but this one especially. It had gotten to a point, and I had 3 concrete examples in a row come to my desk, and they were really terrible examples of safety resources, had the children, no services provided to the parents. Parents got back involved with the children were hurt, bad examples. And he saw that and said, okay, he has issued to his staff directives that they have, any case in which a safety resource has had children for more than 45 days has to be staffed with their SAGs. Have you all heard this, SAGs? Yes? Good. So you've heard that.
Yeah, I got hit with a lot of them.
Oh, right? And I know, I was like, SAGs are going to everyone's going to be angry with me, but it's important. It's imperative because you either need to have,
It's a good policy.
right? You need to have grounds to take legal action, or the kids get to go home because there are no grounds to keep the kids out of the parents' home. It's interference with custody. So you got to go one way or the other. So I think, Melinda, I think that the parallel subsequent to that is they're going to try to now say, if we're going to use a safety resource, that's fine. But you also have to have grounds for dependency and need to be filing a petition in court to say these are the grounds and these are what we're asking for in a protective order, or who has custody, or whatever other issues they're trying to address. Does that make sense with what you've heard, or has anyone heard something different? I'm making assumptions because I'm not sure what they were referencing.
We were just informed that everything has to now come as a dependency petition, that there was no longer safety plans that were to be issued.
Well, that I hadn't heard. Has anyone else heard safety plans aren't to be issued? I hadn't heard that.
Now, what I've heard from my department, well, thank you, Ashley. What I've heard from my department is just what your discussions must have been with Director Cagle, and that is that after they've been in the safety resource placement for 45 days, we need to bring a petition to bring it to the juvenile court. And that's, if I don't get back with you on emails or something, it's probably because I'm filing another petition for non-emergency dependency action.
So if you hear more, Melinda, send it to me. Anything like that you all hear, you're also welcome to send it to me because I'm happy to find out the answer for you if it's helpful. So I'm going to go back to the subject matter. Yes, thank you.
Hello, my name is Burrus, and I might be one of the only strictly parent attorneys in the room. But I guess my concern with some of these policies from a parent perspective is we're talking about 10,000 kids that think in defect custody currently. And it seems like we're narrowing the options for children to come into contact with the department such that we're cutting back on safety resources, the amount of time a child is remaining a safety resource, as well as the options regarding temporary guardianship and permanent guardianship. So I know we're talking about wheelhouses and alternatives to families coming into contact with the state, but I'm afraid that many of these policy positions will drastically increase the number of children who are entering defect custody, at least here in Fulton County. So that's my concern.
I'll wait for the microphone.
What? Right, where we have children in hotels and sleeping in the defects office.
And I think it's too soon to,
And there are cases where children come into defect custody and they're not getting the services that they're not getting by virtue of being in a safety resource anyway.
yeah, and I don't think we know yet what data we have to support or not support some of these policies and directives. And the intent is good. Again, it's to prevent misuse. That's what this is. So let me answer that with two pieces. Number one is there are exceptions and waivers. So can we go to the next slide? Thank you.
I'll get it over here.
So it wasn't just me. But the next slide talks about that defects can request a waiver. So that if they do have a case in which they've determined it's appropriate to have guardianship, they can certainly request a policy waiver. But they have to do a thorough assessment of child safety and of family circumstances, which should be done anyways, quite frankly. I will point out it says the bar for obtaining a waiver is high, but it should be, because the goal is to protect these children, provide services to this family so these children can be reunified safely. But this is a mechanism so that temporary guardianship or permanent guardianship in a CPS case where it's appropriate can still be used by the department. Now, not to be the voice of doom, and I work very well and collaboratively with DFACS, and I love Director Cagle and what he's accomplished, but I am going to say this. What's the problem with this? What's the problem any of you see when you have to go to the state for a waiver?
Takes a long time.
Takes a long time, 6 months. Sorry, Deborah. I'm sorry. Generally. But why? Limited resources. I'm not criticizing anybody. I'm just saying generally that can happen. So that can be an opportunity, right, that it can take a while. So that's one piece. There's a way that they can still ask for temporary guardianship. The other thing I would point out and remind you're a parent's attorney. A parent's attorney can always ask for temporary guardianship, can always ask for permanent guardianship. A child's attorney can always ask for temporary guardianship. A child's attorney can always ask for permanent guardianship. When I was a SAG, I can't tell you how many conversations I had. I worked in a circuit where the judge appointed attorneys who practice in that circuit, period. So there was a real estate attorney who had to come to juvenile court. There was a tax attorney who had to come to juvenile court. They didn't want to come to court in juvenile court because it wasn't their expertise. And they had to come. So guess what? They looked to me to file everything. Well, that's all well and good because this is my expertise and don't ask me to do tax. But when I'm in a position representing a client and cannot file for permanent guardianship, and you have grounds to say it's the best option and TPR is not appropriate for your parent, guess what? You better go research and file it. So there are ways to accomplish it. Don't rely on the department to do it. That's my point. If you have grounds, you better start filing because it can still be done even if the department can't recommend it. And if you have a court where the court tends to rely on what the department can recommend, raise your hand if the court you practice in tends to do that. Don't be shy. TV can't see you. If that's the case, guess what I recommend? Start having someone testify or take judicial notice of the defects policy, right? Or have a case manager testify that they cannot do guardianship. They cannot recommend guardianship in all cases. Have some of that evidence presented because then the court might understand it's a matter of practice versus it's not case specific. There's a question back there. Okay, great. I'm almost done.
Permanent guardianships, and this kind of goes to a comment that someone may overhear about when they do permanent guardianships, they incorporate the parent's case plan. When permanent guardianship, when guardianships come here, after the guardianship is granted, defects is out of the process. So when you talk about continuing services, how is that provided when defects is no longer in the picture? In most instances, the case plan, I'm not seeing an instance in our courtroom where the case plan is incorporated into the permanent guardianship, order. Generally, when the permanent guardianship is granted, that's it, case is closed, defects is gone, and that's it until you hear from the permanent guardian 6 months later and they want to send the child back. So how do you go about incorporating services into permanent guardianships when the defect service providers are no longer in the picture?
I'll tell them what I think, and then I'd love for you to maybe give a better answer. I'm just telling you my opinion. I'll give you that disclaimer. I think that's Director Cagle's point. There's not a mechanism to ensure that services are provided when a permanent guardianship is ordered. But let me see if Deborah has something to add.
I agree. I agree, and we recognize that in our policies pretty much before supported doing that. But we realized that once we closed the case, we were gone. And so that's why we have some of the policies that we have that I'm going to talk about before we go permanent guardianship. What's going to be the most appropriate thing to do? Okay.
And I am going to say again, I recognize, and it took me running to Director Cagle to recognize these changes were for very well-intended good reasons. So recognize that. It's a continuing education, training, understanding, thinking outside of the box, being creative, communicating. Come to me. If you have defects offices or communities that aren't doing things or don't understand, or if you've got parents' attorneys saying, I don't know how to file a petition for guardianship, tell them to call me. I will give them a form to do it. Because honestly, it's about doing the best for your client that you can and representing them. Having said that, I like to shake the trees. So I'm going to leave you by shaking this very last tree. Last slide. All right, so the Foster and Connection Acts give states the option of obtaining federal reimbursement for ongoing assistance payments made on behalf of eligible children who exit foster care to guardianship with a relative. What does that mean? Every state has the option to come up with a plan to give money to relatives who become guardians of children, right? To get them out of foster care, to incentivize out of foster care to a guardian. Everybody understands that? Georgia does not have such a plan. There are a lot of states that don't have such a plan, okay? But Georgia doesn't. What does Georgia have? It uses TANF funds. So Georgia does use state funds to have an equivalent type of program to incentivize. So I'm going to leave you with this thought. What does this mean? If you take guardianships off the table, what does it free up? State monies. What do we do with that? How do we policy-wise think about this piece? What do we do with this piece policy-wise to get the best outcome for children?
We apply for those federal funds.
Say that again, we pocket those federal funds? We apply for the federal funds. That may be the best answer. I want you to think about this because all of us know, I learned quickly, everything has a budget. In almost every decision made, there's a budgetary reason. So I'm just leaving you with this thought. I appreciate all of your questions and comments because I learned so much from each of you. And I'm going to turn it over. Deborah's wonderful, so I'm going to learn as much from her as well.
Thank you, Ashley.
Thank you. Burrus, you're up.
It seemed to go quick.
Sorry, somebody got you set up, you okay? Mr. Johnson, do you need to do something? Oh, okay, you're good. You don't have a problem.
I do. I do.
Yes, she has a presentation. She does.
I do.
Yes, she has a presentation.
What is the name?
It's defects. Legal Academy. Very creative.
Okay, so it's called defects?
Yes.
Yes. Okay, I may have to turn this back on in just a second.
Okay, well, if it's gonna take a second,